Hello everyone. I am Advocate Sridhruti Chitrapu. I am the managing partner and the founder of Sodasi Legal Services. We specialize in company and corporate litigation. I have done my postgraduate diploma in insolvency laws from the Indian Institute of Corporate Affairs. And today we're going to discuss about the corporate insolvency resolution process as provided under the IBC. So let us understand what IBC essentially entails. So you must have seen that under the previous regimes, insolvency resolution has been attempted at from different angles by different courts so far, different enactments so far. So now you have already come to a cursory understanding as to why there was a necessity or the need for a new enactment. So when IBC was introduced in 2016, it was essentially to streamline insolvency resolution provided under various regimes, and to streamline the process, it effectively it avoided multiplicity of litigation before different fora, and in turn it reduced overlapping insolvency proceedings or recovery mechanisms before different forums. It also by providing a singular code. It's not an enactment, it's a code. So if when you say that it's a code, it is both substantive and procedural in nature. It entails every single thing there is for in the recovery and insolvency related regime. So it provides a structured and a time-bound process to handle insolvency. We are, for the purpose of this lecture and the couple of next successive lectures also, we will be focusing only on corporate insolvency. However, this code is an umbrella legislation which provides this kind of a mechanism for all entities. Under the previous regimes, as you must have seen in the previous lectures, insolvency procedures were very tedious and long drawn. But by bringing in IBC, and at every stage is marked by timelines and milestones, as you will see in the coming parts of this lecture. The stringent timelines allow the creditors to realize their debt, and for the debtors also to have a clean exit strategy. This will not only encourage entrepreneurship, but this will also encourage incentivize the creditors to give more loans, in turn making the economy move, right? So let's look at why there was a need for IBC. You have seen that as per the previous regimes, the recovery rates under the multiple previous regimes, was very inefficient, and the recovery rates were very low. And because of the long drawn processes, there was a significant value erosion for the plant and machinery of the companies, which in turn is naturally resulting poor recovery rates for the creditors. So there was a need for an umbrella legislation such as this to bring quicker resolution with maximized profits. So these are the objectives of bringing in the Insolvency and Bankruptcy Code. Primarily, maximization of asset value. So IBC provides a creditor-driven process of recovery and insolvency. So when there is a creditor-driven process and when it is strictly time-bound, it avoids avoids the plant and machinery to erode or depreciate in value. Because under CIRP, as you will come to see, the primary concern is to keep the unit as a going concern. If you keep the unit as a going concern, all of the plant and machinery and the operations of the business are still ongoing. When that happens, you will not only avoid corrosion or depreciation of the assets, but you will also, there is a possibility that in the right hands, there is a possibility to turn profits, in fact. So insolvency can happen either due to operational failures or management failures or financial failures. If it's either a management failure or a financial failure, it means that the people who are handling the company, the key personnel, key managerial personnel, or whoever is handling the day-to-day operations of the business has failed in some way in maintaining the company and avoiding insolvency. If there is an operational failure, that's a different matter altogether. It could mean that the business idea itself is not viable. However, in the first instance where there's a management failure or a financial failure, it can indicate that under the right regime, under the right management, the company could actually turn profits. So there will be maximization of asset value because there are specialized people and appointed for handling these companies under distress, and they are also allowed to appoint and take the necessary aid from professionals to run the company. This is a time-bound resolution process. So as per section 12 of the code, the process needs to be completed within 180 days from the commencement. The CIRP process needs to be completed within 180 days of the commencement. However, if by whatsoever reason this CIRP is not able to be concluded within that 180-day period, then they may approach the NCLT, which is the adjudicating authority, for an extension of 90 days. Subsequent to which, if another additional period is also required, they may put in another application for extension requesting for a 60-day period, which comes up to a total of 330 days. This extension may be granted by the NCLT solely on discretionary purposes or solely on discretionary criteria. It is not a mandatory thing that they give you 330 days, but in a practical sense, there are several challenges on a day-to-day basis. So this extensions are generally granted in most cases, but it is completely discretionary. And coming to balancing stakeholder interest. So there are various stakeholders in any company. Like if you look at a company, there will be consumers, there will be management, there will be creditors, and there will be debtors. You will have sundry creditors and sundry debtors who are in direct and regular contact with the company. So the code provides specific provisions to take care and cater to the interests of all of these stakeholders in an equal pedestal. So when I say an equal pedestal, it does not mean that the recovery is going to be equal. You're going to see in the subsequent sections. But what I mean is all of their interests are actually taken in regard and considered during the process. However, this was not the case in the earlier regimes, right? So, and as I have already told you, this naturally promotes entrepreneurship, as it encourages a healthy business mechanism where it's easy for the corporate debtor also to enter and exit the economy, the business economy. So now let us look at the general overview of the corporate process under in IBC. So let's look at when does IBC get triggered in the first place. So IBC can get triggered when a company defaults on debt. So let us understand what a debt means. So a debt can be understood as provided under Section 5 as a financial debt or an operational debt. Let's look at the debt, what it means in itself before looking at the subdivisions. So Section 3, subsection 11 provides that debt is a liability or an obligation in respect of a claim which is due from any person and includes a financial debt or an operational debt. We will look at what a financial debt and an operational debt is in the subsequent portions. So when a liability in respect of a claim is defaulted, and by default we mean the non-payment of whole or any part of the debt which has become due and should have been paid. So under these circumstances, an insolvency proceedings can be initiated under the IBC. Corporate processes under IBC can be initiated. And the process, as we have already seen, involves multiple stakeholders: debtors, creditors, employees, government agencies, multiple stakeholders. And there are two possible outcomes in a corporate process. Primarily, resolution. If resolution fails, then subsequently liquidation. So the adjudicating authority under the IBC is, there are various adjudicating authorities for different aspects. For corporate processes, NCLT or the National Company Law Tribunal is the sole adjudicating authority, and it has benches in several states of the country. And the appellate tribunal happens to be National Company Appellate Law Tribunal, which has two benches in Delhi and Chennai. And the adjudicating authority appoints insolvency professionals to manage the corporate process, may it be CIRP or liquidation, in the roles of an IRP, RP, or a liquidator. IRP refers to an interim resolution professional, or an RP, which refers to a resolution professional. In the subsequent portions, we will be looking at each of their roles and responsibilities as well. So let us look at various stakeholders under the IBC. So let's look at what a corporate debtor is. A corporate debtor is basically any corporate entity as provided, as registered either with the Companies Act or as registered as a limited liability partnership under the Limited Liability Partnership Act, which has taken a debt. So any corporate entity which has a debt and has defaulted can be subjected to the corporate processes under the IBC, which is called, and in turn be called, as a defaulting company. And there are multiple types of creditors. We will firstly look at financial creditors. Let's understand who are financial creditors. Financial creditors are the type of creditors to whom a debt of financial nature is owed. So we will look at what the exact definition of a financial debt is. So financial debt is provided under section 5 subsection 7 subsection 7 and subsection 8. Financial creditor means any person to whom a financial debt is owed, and such debt may be either directly owed to them or has been legally transferred or assigned. Now let us understand what this entails. A financial debt is a debt along with interest which is disbursed against the consideration for time value of money, which includes money borrowed against payment of interest. Any amount, money borrowed against payment of interest could be any loan transactions, ordinary loan transactions that take place with any bank or financial institutions. Any amount raised by acceptance under any acceptance credit facility or dematerialized equivalents. So this refers to any security or such other dematerialized credit instruments. Any amount raised pursuant to any note purchase facility or issuance of bonds, notes, debentures, loan stocks, or any similar arrangements. So this means that any amount raised from either the public in general or under any of the credit instruments. In the prior instance, it could be any acceptance of any credit facility. It can mean something like a letter of credit of such nature. Fourthly, the amount of any liability in respect of any lease or hire purchase contract which is deemed to be a financial or a capital lease. So, as per the accounting standards, so any lease deed with such terms and conditions which will eventually, the nature of the contract itself will turn the lessee into the owner at the end of the loan period, at the end of the lease period. Any lease of such nature will be considered as a financial lease. Receivables sold or discounted other than any receivables sold on non-recourse basis. This amounts to ordinary sale of sundry debt. Any amounts raised under any other transaction, including any forward sale or purchase agreements having commercial effect of a borrowing. So here it is pertinent for us to concentrate on the commercial effect of a borrowing aspect of the definition. Let us look at the example, and I think we will be able to understand it better then. Any amount raised from an allottee under a real estate project shall be deemed to be an amount having the commercial effect of a borrowing. So, in real estate projects, as you must have seen in multiple advertisements that you come across, any real estate developer seeks for an initial down payment, right? So this initial down payment is collected from all the allottees of a project and it is utilized towards building of the project. And as a as a perk for investing at such an initial stage in the company, or rather providing an amount even prior to taking the possession, is a forward sale. The asset in itself does not exist as of that day. They are purchasing it prior to its existence to aid in its creation. and as a result, they receive it at a discounted rate compared to the buyers or the allottees that come into possession at a later stage or after a completed a buyer that comes in at a completed stage. So this discount is considered to have a commercial effect of a borrowing, because this is in the nature of it's in the nature of a loan. The builder is raising money for the development, right? So these allottees in a real estate project, or like in the prior instance where we have seen debenture holders or such other credit instrument holders, are referred to as a class of creditors. If there are not less than 10 creditors of the same nature, can be called a class of creditors. So such class of creditors is provided, the definition for it is provided in the CIRP regulations provided along with the code. So we will see the complexities that arise in cases where class of creditors are either part of the process or are initiating the process. There are a few nuances that we will have to look into. Then coming to any derivative transactions entered in connection with protection against or benefit from fluctuation in any rate or price, and for calculating value of any derivative transactions. Any transaction, derivative transaction against the value of an underlying asset, and only the market value of such transaction will be taken against the underlying asset. So derivative transactions of such nature are also considered a financial debt. Any counter indemnity obligation in respect of a guarantee, indemnity, bond, document, letter of credit, or any other such instrument issued by a bank or a financial institutions. So bank guarantees or such other instruments will be considered as a debt as well. And finally, any of the above, if a person stands as a guarantee or provides indemnity against any of the other transactions, even for a company, any person or any other corporate entity which stands as a guarantor, will also deem to have a financial debt, and proceedings may be initiated against them just the same as against a principal borrower. They will stand on the same footing. Now let us go back to the next definition. Operational creditors. Operational creditors refers to a person or an entity to whom an operational debt is owed. Operational debt can be of different nature, multiple different categories. It could be operational creditors as in suppliers who have a regular relation with the company. They generally tend to have a running account where they have a standing purchase order and multiple transactions take place. Or there would be employees. Naturally, there will be regular payments to them. And there could be statutory operational creditors as well. Statutory operational creditors entails government departments, central government, state government, and such other local authorities. All of them come under operational creditors. Interim resolution professional and resolution professional. So these, as we have already seen, they are appointed by the NCLT to supervise and take control of the company during the corporate processes under IBC. They handle the day-to-day mechanisms of the company. and they play a very important role, which we will be looking into in the subsequent portions. Committee of creditors. Committee of creditors, as IBC is a creditor-driven process, is the decision-making body. So there are, for each category of decisions to be made, there are different percentages that need to be, different percentages of voting that needs to take place. Committee of creditors also plays a very crucial role in determining how much interest, how much recovery is actualized, and how the company is run. We will see in the subsequent portions of the lecture. National Company Law Appellate Tribunal. The adjudicating authority has the authority, adjudicating authority, the NCLT has the jurisdiction, the sole jurisdiction to either approve or reject resolution plans, applications for initiation of CIRP or liquidation, or various other such related proceedings. They are the sole adjudicating authority, and no other court, not even the High Court, can entertain petitions relating to IBC. The Supreme Court has time and again stated that, even in the recent case, most recent case also, has stated that not even a High Court can interfere in the IBC proceedings. And the non-obstante clause in the IBC provides a very strict and stringent outline stating that IBC supersedes any other law related to recovery and insolvency processes. So let us look at who can initiate IBC. There are different stakeholders who may initiate IBC proceedings. Financial creditors may approach the NCLT and file an application under Section 7. So for us to look at Section 7, the financial creditor needs to file an application under Section 7 along with Form 4. Financial creditors are required to file the Section 7 application along with Form 1 and Form 2 as provided in the Application to Adjudicating Authority rules. So we will look at both Section 7 and we will look at the Application to Adjudicating Authority rules. Primarily, let us look at the code. So, coming to Section 7. A financial creditor, either by itself or jointly with other financial creditors or on behalf of financial creditors, may file an application to initiate the insolvency process when a default has occurred. So, ordinarily, if a default has occurred, the limit provided under the code under Section 4 used to be a minimum of 1 lakh. However, post-COVID, due to multiplicity of litigation and also due to several business hiccups that have been caused due to the pandemic, the government has notified that the minimum default has to be over 1 crore. So any default over 1 crore, a financial creditor may file an application. And in case of class of creditors, as I have told you earlier, a class of creditors can file they can file jointly either 100 of such class of creditors or not less than 10% of such creditors, whichever is lower. If there are, say, suppose 200 people in a real estate project, the 200 allottees in a real estate project, then either 100 or 10% coming up to 20 allottees may file an application, whichever is convenient. So this application has to be filed in accordance with the adjudicating authority rules, which is provided in Rule 4. So Rule 4 states that a Section 7 application is to be accompanied with Form 1. And we will look at what the form also entails. This is essentially in the form. It is enclosed in the application to adjudicating authority rules itself. It's a very simple process, and a financial creditor is just merely required to fill up the form and provide the requisite details as provided in the rules and in the code. So we'll look at the code again. The code says a default, which is a default, may need not necessarily be a financial debt that is owed to the applicant itself. It can be could have also been defaulted towards any other financial creditor of the corporate debtor as well. Say suppose there is A and there is B who have given a financial credit to a company XYZ. If XYZ has defaulted on the financial debt given by A, B also who has a financial debt may file an application. A default includes a default in respect of a financial debt owed not only to the applicant but a financial creditor. In a practical sense, it's generally not what a person would do, because you would not want to incur the expenses of litigation on behalf of someone else, but that is also provided in the code in the eventuality that might be an issue. Financial creditor shall, along with the application, provide a record of default. So a record of default recorded with information utility. Information utilities have been established under the code for retaining and providing financial information about any corporate debtor or any corporate entity. The aim in the long run is to have financial transactions recorded in there about all of the business ongoings, so that it will provide a credible database for the courts to rely upon. So any information fed into the information utility is verified and hence understood to be a credible source of information. And it will be considered as a clear evidence of default. That, and subsequently, if marked as a default, it will be understood as an evidence of default as well. And the application is also to be accompanied with the name of a resolution professional who is to act as an interim resolution professional. Any insolvency professional recommended or proposed to be appointed as an IRP must not have any disciplinary proceedings pending against them, firstly. Secondly, the insolvency professionals are required to take up only up to a certain number of cases, and they should not have crossed that requisite limit, and they may be appointed. If they meet with both these criteria, they may be proposed to be appointed, or any such other information as specified by the board. For the application, a cost of 25,000 is also to be paid. Upon filing of this application, within 14 days, the adjudicating authority is to ascertain if there is a default from the records of the information utility or on the basis of evidence furnished by the financial creditor. So, in cases of a Section 7 application, generally the registry and the court require that a financial creditor submit the details of an available within information utility. It has become procedurally mandatory for them to submit the evidence recorded in the information utility. And if the adjudicating authority has not ascertained the debt or existence of the debt or default, shall record its reasons in writing for the same. So the timeline is very strict on the adjudicating authority as well as per the code. But in practicality, there are several challenges in this. There is infrastructure challenges, and there is a huge vacuum in the appointments and the number of personnel sitting on the bench as well, which has created a huge lag even in NCLTs. So the Supreme Court has time and again stated that the timelines provided under the IBC are binding and mandatory towards the IRP or the RP or the liquidator, but are recommendatory towards the NCLT. It is recommended that the NCLT follow this timeline, but it is not mandatory. And if the adjudicating authority is satisfied that the default has occurred and that the application is complete, then they may admit such application and commence the insolvency proceedings. If that application is found to be either incomplete or if there are any disciplinary proceedings pending against the insolvency professional, then that application may be rejected. But before rejecting the application, the NCLT is required to provide 7-day period for rectifying such defects to the applicant, subsequent to which they can adjudicate whether there is a debt or not, a default or not. And an insolvency professional is also required to submit Form 2 along with the Section 7 application. Form 2 is essentially a consent form stating that the insolvency professional is eligible, is not a related party, and does not have disciplinary proceedings pending against them. So let us look at how an operational creditor may initiate proceedings. The procedure for an operational creditor to initiate proceedings is slightly different from that of a financial creditor. For an operational creditor to initiate proceedings, they are required to issue a demand notice under Section 8 of the Code. So, upon default, the Code provides that an operational creditor is required to give a notice demanding payment of the unpaid amounts, and there is a format for this as well. Form 3 of the Application to Adjudicating Authority rules provides a format for notice of default, and it provides a 10-day window for the corporate debtor to make the requisite payments of the defaulted amount. If they fail to pay within that 10-day window, then the operational creditor may proceed with filing an application under Section 9 of the Code. However, if the corporate debtor either pays, refuses payment on basis of a pre-existing dispute with the corporation creditor or refutes the amounts of payment, amounts of default, it is deemed to have a pre-existing dispute. If there is a pre-existing dispute, then the jurisdiction does not lie with the NCLT and an operational creditor cannot approach the NCLT under Section 9. The disputes are to be settled before coming to NCLT. NCLT merely looks at insolvency and recovery mechanisms. Such other civil disputes will have to be addressed at the right forum. If there is no payment, no notice of pre-existing dispute, then an operational creditor under Section 9 will submit an application. So for an operational creditor to submit an application, they will have to submit a record of default. They also have a provision to submit the details of the transaction with the information utility. However, it has not procedurally been mandated yet. It's optional, and it is suggested that an operational creditor, if they have the details of it on the information utility, they have to submit the demand notice that they have given under Section 8 and an affidavit stating that they have not received the payment, they have not received any notice of pre-existing dispute from the corporate debtor within that 10-day window. And they have to file bank statements or account statements to show that such amount has been defaulted and has not been received by the operational creditor. For operational creditors, it is optional for them to suggest or propose the name of an insolvency professional who is going to act as an IRP. It is optional. They may choose to do so. If they choose to do so, then along with that application, they are also required to submit a consent form of the insolvency professional. So the process for the operational creditors, the filing procedure is provided under Rule 5 of the Adjudicating Authority rules. Rule 4 provides the details of the demand notice, and Rule 5 provides for the details of the demand notice, and Rule 6 provides for the application procedure. And coming to corporate debtor. Corporate debtor itself, through its key managerial personnel, directors or partners or managing personnel in whatsoever capacity, can file an application under Section 10 to initiate the insolvency proceedings. So for initiating corporate proceedings under Section 10, a company must have, along with the application, furnish books of accounts, information relating to, they are also mandatorily required to propose the name of a resolution professional. And again, the company consent form is also to be accompanied, and a special resolution of the shareholders, at least 3/4 of the partners, a resolution of the partners in case of an LLP must be filed. And in case of an application filed by the operational creditor, the application will have to, the cost of the application is 2,000, and in case of corporate debtor, it's again 25,000, as in the case of financial creditors. Now, let us look at what happens after the initiation of insolvency proceedings. So once the corporate insolvency resolution process is commenced, an interim resolution professional is appointed. An interim resolution professional, his first and foremost duty is to take custody and control of the assets of the company. Once the order of commencement has different parts to it. It appoints the IRP, it declares a moratorium, and it directs the IRP to take the custody and control of the company, and it directs the IRP to give out a public announcement stating that the company is under CIRP and is subject to moratorium as per the provisions of Section 14. So the moment the IRP takes control, within 3 days of being appointed as the IRP, he is required to give a public announcement in the newspaper, the local newspapers of the registered or address of the company, declaring that the moratorium has been imposed and inviting claims. Other than the applicant also, there will be other creditors or stakeholders who will have a claim against the company. So the IRP invites claims from all such creditors and requests for them to file their respective claims within a stipulated time. A 14-day window is primarily provided. So under Section 14, let us understand what moratorium means. Moratorium is basically a frozen period provided to the company where no lawsuits against the company can be initiated. None of the assets of the company can be transferred. No debt recovery proceedings under any other law can be initiated. Not even SARFAESI proceedings can be initiated. And no recovery of property that is of the corporate debtor can be recovered during this process. But moratorium does not exempt proceedings being initiated against the directors or the key managerial personnel of the corporate debtor. Also, the guarantors, the proceedings against them will not be covered under the moratorium. So moratorium imposes a very strict period and it remains in effect until either the order for resolution is passed or the order for liquidation is passed. And let us look at the role of IRP and RP. So as I was stating, the first and foremost thing that an IRP does is take control and management of the assets. So on the first day, the IRP goes and takes control of the cash and cash equivalents of the company and puts up public notices in the company, and lets the employees know that the company is under CIRP and that they are to report to the IRP from then onwards. Once the commencement takes place, the IRP will be taking over the responsibility of the board and the management of the company. Hence, all the employees are also required to report to the IRP. And secondly, the IRP verifies the claims that he has received from the public announcement. So once the public announcement is made, so all of the other creditors, financial creditors, government departments, statutory creditors, and employees, workmen, and such any other category of creditors will file respective claims. Once the claims are received, the IRP is required to verify these claims, the credibility of these claims again, and also cross-check it with the records of the company and any other evidences provided by the creditors. The IRP will also take possession of the books of accounts and all of the documentation as required for verification of claims and to continue the going concern of the company. And the IRP shall constitute a committee of creditors. So the IRP, post receiving the claims, shall constitute a committee of creditors with financial creditors. So the committee of creditors solely includes financial creditors. In the absence of financial creditors, if there are zero financial creditors, then the committee of creditors may constitute 18 largest operational creditors. And if the company does not have as many operational creditors, all of such operational creditors and representative of the employees and a representative of the workmen shall be made part of the committee of creditors. So the committee of creditors constitution report must be filed by the IRP by the 21st day. The IRP will be receiving claims within 14 days of his appointment, and a 7-day period is given for verification of claim coming up to 21st day, and before the on or before 23rd day, a committee of creditors is to be constituted. Once the committee of creditors is constituted, they shall appoint the resolution professional. In case of class of creditors being part of the insolvency proceedings, in real estate cases, the IRP shall provide names of 3 insolvency professionals who have no disciplinary proceedings pending against them and who are not related to the corporate debtor or any of the stakeholders in the newspaper application itself, seeking the class of creditors to submit their preference of the authorized representative and along with their claim. So this authorized representative appointed by the allottees or the class of creditors shall represent them in all of the meetings of the committee of creditors and shall vote on their behalf in the committee of creditors. So the COC will have voting rights in proportion to the size of their debt against the total debt of the corporate debtor. The resolution professional, or if is not appointed on or before 40th day, the IRP shall be deemed to be the RP and will continue his duties in managing the company corporate debtor and in continuing the resolution process. So the IRP plays a very important role in collating the claims and constituting the creditors. Subsequently, may also play a role as the resolution professional in continuing to manage the company. So the CIRP process stresses on the need for a corporate concern to be kept alive and to conduct itself as a going concern. And a resolution professional is empowered to appoint any such professionals as may be required to aid and assist the process of managing the operations or day-to-day operations of the company. So, the resolution professional, once the claims have been collated and filed, at every stage, the insolvency professionals are required to keep updating the IBBI and provide updates to their respective insolvency agencies as well, insolvency professional agencies as well, for public disclosure. Basically, this system not only enables quicker supervision and efficient management, but also to keep the stakeholders informed about the status and the manner in which the CIRP is taking place. So the resolution professional invites bids for the resolution process, and he appoints valuers and he appoints transaction auditors and any such other professionals which are required for the invitation of the bid as well. So I have worked on a case where we were required to seek the court for a CBI investigation against the corporate debtor to get the documents of the corporate debtor in our possession. So the IRP is a court-appointed officer. He is empowered to take any such necessary action to safeguard the interests of the company and to keep the company as a going concern. So in that instance, the management of the corporate debtor was not cooperative, and we weren't able to get access to the documents of the company, which will obviously hinder the process and will not enable us to invite bids for the resolution plan. So we were forced to approach the NCLT. So the IBC process under section 19 and subsection 2 enables a resolution professional or an IRP to file an application against the management of the company, of the corporate debtor, if they are not cooperative or if they are not providing the IRP or the RP with the requisite data or documents relating to the company. The IRP may even IRP and RP may even go to the extent of seeking the aid and assistance of local authorities, as in they can take the assistance of police as well, with naturally the approval of the NCLT. Regulation 30 provides for this. Regulation 30 of the CIRP regulations enables the IRP to file an application and take assistance from the local authorities. So an RP shall take all such necessary measures and provide an invitation for an expression of interest from the prospective resolution applicants. So we will look into the details as to how the process, as to how the bids are invited and how the information about the company is projected to the prospective resolution applicants in the successive lecture. We will also look at how the CIRP process is conducted, is concluded. We have already seen part of the process in this lecture. The subsequent part will be dealing with the resolution process related negotiations and case laws by the Apex Court and NCLAT. Thank you for today. We will be continuing in the next session.